I'm delighted to be part of this panel, and I would like to thank the organizer for inviting me. Having been the counsel in charge of the French team for a number of years, it's really, I consider, a great opportunity to share some of the experience I've had. I was lucky to have seen 3 different arbitration sets of ICC arbitration rules enter into force and in practice, and I'll get back to that a little bit later. So, coming back to the words of Charles in opening, the ICC arbitration rules have to date been in 9 different versions from 1992 to 2021. And our conversation today is about 100 years of arbitration proceedings run from Paris. But it would not be fair from me not to mention that actually, beyond arbitration proceedings, it has been 100 years of dispute resolution rules being run from Paris. And that includes work that the ICC does with respect to appointing arbitrators under the ICC appointing authority rules, as well as the work that the ICC International ADR Center has done over the years in administering a number of alternative dispute resolution proceedings with mediation rules, expertise rules, dispute boards, and doc decks for financial documents disputes. Now, that little caveat being made, I wanted in this conversation to focus on the major changes that were done within ICC rules in the past 3 versions of these rules, 2012 up to 2021, and which are those that I have had the privilege to live with. I remember when I joined ICC, actually in 2012, right after the 2012 rules were entered into force, there was an air of panic within the Secretariat because those rules came with major changes compared to the previous set, which was the 1998. Among those major changes, features such as, which now appear completely normal to most of us, but features such as the emergency arbitration, the prima facie test, Article 6, Paragraph 3, of course, not in the test done by the court, but the preliminary test done by the Secretary General, the codification of multi-party, multi-contract situations with Articles 7, 9, and 10, and also the rule relating to constitution of tribunals in situations of lack of alliance of parties under Article 12.8, which was an immediate reaction to French courts' jurisprudence in the Dutco case. As I said, some of these, a number of these changes did create a little air of panic within the Secretariat because it meant for the staff of ICC changing the way we were approaching generally those decisions. So if you look at Article 6, Paragraph 3 with the prima facie decision, suddenly we were no longer briefing the court systematically for every single objection to the jurisdiction of the arbitral tribunal or even objection to the matter proceeding with respect to a party, but we would have an internal process of submitting that primarily to the Secretariat, the Secretary General of the court, and he would decide based on the briefing of the Secretariat whether or not that conversation warrants being directed to the ICC court. The objective of such a change, which was wanted by the drafters of the rules, was to gain time. We're coming back to I think one of the most important elements that has driven ICC arbitration in the past decades, which is the sort of efficiency. Indeed, before, under Article 6, Paragraph 2 of the 1998 rules, every single objection of that sort would be submitted to the ICC court, even when those objections were in a way superficial or would not warrant any substantive examination by the court. So that, as a first change, was quite interesting to experiment. More importantly are the situations that Article 7 and 10 had brought about. And the reason for that was that these were entirely new in the practice of the Secretariat. Of course, they were also born from the practice, because the ICC had obviously situations where parties were joining additional parties during the life of proceedings, but it was never codified, and there was no clear process as to how that should be done and when those cases should lead to accepting or not an additional party. And I do remember having in the case management team I was in at the time as a junior counsel, dealing with one such case of joining an additional party where the opposing counsel was resisting the joinder on the basis at the time that no claim was formulated against the additional party. And Article 7 of the rules, which refers to Article 4 of the ICC rules, has among the requirements of filing of a request for joinder or for arbitration, the fact that a party should lay down the claims that are formulated against the other party. And at the time, again, nobody knew whether that should warrant the Secretariat to refuse the joinder of the additional party, bearing in mind that the Article 7 does not require the Secretariat to go through the court. So that was a decision that was made within the Secretariat, and particularly resting on the shoulders of the Secretary General himself. The last changes that I mentioned is the one of Article 12.8 brought about by the Dutko case. And again, one very important change of paradigm in arbitrations, not just within ICC, but generally in the arbitration community, where suddenly the right for a party to nominate its arbitrator was no longer a given, and where the institution could step in and authoritatively decide that, given the lack of an alignment between the parties, the institution itself would nominate all three arbitrators, even in scenarios where one of the parties, usually the claimant, would have done the exercise of nominating its own arbitrator. These changes have been, as I said, quite felt in a quite intense manner within the Secretariat and also within the arbitration community, and the Secretariat being in the front line in responding to parties and council of parties, I should say, and arbitral tribunal members, has spent numerous hours over the phone trying to explain things that itself was not always at the time comfortable with in how to implement those changes. And we were just getting used to those 2012 rules when the ICC court decided to change the rules again 5 years later with the 2017 rules. And there, a new important change of paradigm came about. You all remember 6 years from today that we were intensely debating whether the ICC court was not losing its mind when it was talking about introducing the expedited rules. That in and of itself was not a problem, but was deciding to override the arbitration agreement of the parties, that was how most commentators were qualifying it at the time, by deciding that even though parties would have agreed to a 3-member arbitral tribunal in their agreement, whenever the dispute was below a certain amount, which at the time was $2 million, the ICC would have the authority to appoint one single arbitrator. Those conversations have occupied us for numerous conferences and hours, and today, 6 years later and 456 cases later, 240 arbitral awards later, we know that this is no longer an issue. And that, I think, is a very strong example of how ICC has contributed to not only increasing efficiency in international arbitration, but building trust. We start by questioning, by resisting change, but we all come on board and realize that actually, guess what, it works. And not only does it work, but I'm looking at one representative of a company which is very in favor of those expedited rules, and that is Alma Forgo from Airbus arbitration team. And we know that our clients today are saying, we think these rules should actually apply in an even bigger number of cases than what they are restricted to today. And without any fear, we would go through that process, even for important amounts in disputes. And that shows the strength of this type of changes. 2017 and another 6 years later, actually not 6, another 4 years later, the ICC court decides that, well, we could do some more changes, we could adapt again to the scene of international arbitration. And that is the 2021 ICC rules, which are the ones currently in force. With the 2021 ICC rules, the court has primarily sought to bring in the ICC rules changes with respect to integrity and integrity of the procedures and efficiency, transparency, and that was the work that the court did by codifying certain things in the ICC, in the arbitration practice that were felt not to be as efficient as they could be. We heard Charles talking in his opening remarks about a number of professions that were born from the practice of arbitration, experts, tribunal secretaries, others. One such profession are third-party funders. 20 years ago, they were virtually absent from the scene, and even, I mean, 20, I'm generous, even 10 years ago, they were still in the beginning of their activity. And nowadays they've become such a reality that ICC has decided in Article 11 of its rules to address one essential matter that this new profession has created for the practice of arbitration, and that is the fact that the presence of a funder behind a party should be disclosed to allow arbitral tribunals to do to proceed with their duty to disclose any potential conflicts that may arise from the presence of a funder. I'm conscious that time is running, so I will get quickly to the end of my presentation. Some additional changes that were brought with respect to efficiency and transparency, and that were, I would say, forced by the recent the recent changes in our history, namely the pandemic, are the introduction of provisions with respect to filing of requests of arbitration in electronic formats, changes that allowed clearly the possibility for virtual hearings, and other changes with respect to case management techniques that unfortunately I will not address, but happy to address in the questions. Now, these changes in the ICC rules are not the only ones that we've seen over the past years. The ICC, the infamous ICC note on the conduct of arbitral proceedings has had a very intense life over the past decade. And just some of the changes that were brought about through this ICC note, which is not the rules, but is a document that codifies a number of practices from ICC court and the Secretariat, are obviously the possibility to request reasons for certain decisions made by the ICC court, the introduction of sealed offers for arbitration costs, the introduction of disclosure guidelines for arbitrators being appointed on ICC arbitration matters, and other features that maybe were not so known to the public and that Emmanuel has mentioned, such as the possibility to have escrow accounts within the ICC Secretariat to be assisted for organizing hearings, or having list procedures led by the ICC Secretariat. Talking about the Secretariat, I would like to take a moment to give you also a little overview on how the ICC Secretariat has contributed to the past 100 years of the life of the court. That Secretariat is an extremely talented and professional body made of professionals from over 30 nationalities and speaking over 30 languages, different languages, which allows the ICC court to offer its services in virtually any languages. We have ICC court sessions that are held in English and French, but also in Arabic, Portuguese, Chinese, German, Hebrew, Italian, indeed, and that is something that no other institution in the world is able to offer. I will come quickly to the case management teams, but I wanted to also mention here that it would not be fair to be celebrating the past 100 years without recognizing that within this ICC court staff, there are a number of people who are contributing on a daily basis to the work of the ICC court and that are unknown or less known to the public at large. And these are the colleagues in the operational support teams, those who are behind platforms such as Case Connect, those who are more importantly within the documentation center of ICC, which is the living memory of that institution, and without whom most of the work that we all do would not be possible, because they are the ones who are archiving and consigning on a daily basis the decisions of the court, the publications of the court, and within the bulletin, and the work of the Secretariat. Finally, the educational teams and the marketing and promotion teams. To conclude my words for you today, I would like to also mention the incredible developments that we've seen within the ICC Court Secretariat, which started with case management teams based solely here in Paris at the headquarters, but over the years has expanded globally. And we've seen from 2011 with the opening of a case management team in Hong Kong, followed by 2014 with the team in New York, closely followed by Brazil in 2017, Singapore 2 years later, and finally in 2021 a case management team in Abu Dhabi. We're now present in all continents of the world except Africa, but that will change soon, hopefully. And I think that presence of the ICC court everywhere in the world shows the strength of that institution beyond, of course, those arbitrations being run from Paris here at the headquarters of ICC. We have been running those arbitrations virtually from anywhere. Thank you very much.